Hello veterans, AKV employees, everybody out there. Hey, welcome to the channel here at Veteran Lang. Always glad you're here. It's a great Tuesday. I hope everybody's having a wonderful or tremendous, terrific Tuesday. I always bring back the oldie and goodie there. The tremendous, tremendous Tuesday. Hey, as always, I'm your friendly VA credit attorney, Matthew Lang, here with another video about some VA benefits, VA compensation in particular for you here. So here's what we got. We got a new CAVC decision from April 13th of 2026. It's going to explain some important AMA rule. Not every VA statement labeled favorable finding or favorable actually helps the veteran. And only true favorable findings bind future VA adjudicators. So the court had also addressed evidence window arguments and why prejudice still matters. And here's what veterans, VSOs, and advocates may need to know. So if you see the words favorable finding in a VA decision, do not assume you just won something important. Now you're going to usually find these words at the bottom of the decision's narrative for each condition. So if you have a condition that you claimed for, say, back, you're going to look for that decision there on the narrative piece that has a bunch of those words and paragraphs for you there. And towards the bottom, you usually find something that says favorable finding. Now, why do we not want to assume that you just won something important? Well, because sometimes VA labels something as favorable when it is not really favorable at all. And that matters a lot under the Appeals Modernization Act. Why, you may ask? Well, because under AMA, favorable findings can bind later VA adjudicators. So if VA mislabels something, veterans can get confused fast. That is exactly why the court's new decision in Ortega v. Collins matters. This case gives us a very practical rule. Only findings that actually help the veteran are binding. So not all favorable findings are binding. Only findings that actually help the veteran are binding. Not everything in VA claims are favorable, that the VA calls favorable. Not all of them are truly favorable. So let's break it down. I'm going to walk through what happened in the case, what the court held, why this matters in real life, where veterans get into trouble, and what you should do when VA uses language that sounds good but may actually hurt your claim. This video, again, is for general education purposes only. It is not legal advice for your specific cases, veterans. Every VA claim depends on the facts, the evidence, and the law that applies at the time. So before making a decision about your own claim or appeal, consider speaking with an accredited representative, perhaps a VSO, a VA accredited agent, or a VA accredited attorney, myself, or any of them out there. If you're looking to speak to myself and would like a free VA case evaluation, don't forget veteranlang.com is the easiest way to get to my calendar and schedule that time. We do help veterans nationwide, so it does not matter where you live. We can always do a phone call. Now, if you're new to the channel, it's about practical veterans law, VA claim strategy, and what these decisions mean in real life, and everything in between to help us make a smoother process for the future. When it comes to veterans getting those benefits they rightfully deserve. All right, let's get started with the case. Again, the case is Ortega v. Collins. It's decided by the U.S. Court of Appeals for Veterans Claims. It was decided on April 13th, 2026, and actually argued back in December of 2025. The court addressed two main issues. First, whether the board created a due process problem by sending notice about the 90-day evidence window after the window had already passed. And then second, what happens when VA lists something as a favorable finding even though that finding does not actually help the veteran? Now the court's big practical answer on the second issue is the part I want people to understand. Only favorable findings are binding. That sounds obvious. But in VA law, sometimes obvious things need to be said out loud. The court said Congress made favorable findings binding under the statute, the Appeals Modernization Act. But the word favorable still has to mean something. It has to mean a finding that is advantageous to the claimant or the veteran, or that actually helps the claimant or veteran get the benefit. And that's really the key point. So if VA writes down a finding and labels it favorable, but the finding actually makes your claim harder, That finding is not binding just because VA used the label. That is huge. So now let's talk about the facts in plain English. Ms. Ortega was appealing several issues, including foot claims. In the agency decision, VA included a so-called favorable finding that her foot conditions existed before service. That may sound harmless at first. Some people might even think, well, at least VA found something. But here's the problem. In her situation, a finding that the condition pre-existed service was not good for her. It was the opposite. And why was that? Well, that was because if VA says the condition pre-existed service, that can take away the presumption of soundness, which is usually a very important protection for veterans. And once the presumption of soundness is out of the picture, the case can get harder. So the court said, in substance, hold on. Just because VA labeled the finding favorable does not mean it actually was favorable. And because it was not favorable to Ms. Ortega, it was not binding on future VA adjudicators. Now, this is a real-life lesson. A favorable finding is not magic language. The label alone does not control. What matters is whether the finding actually helps the veteran get the benefit. Now, let's pause here. Because this is where a lot of veterans and even a lot of representatives can get tripped up. Under AMA, favorable findings matter because they can lock in helpful parts of the case. For example, if VA favorably finds that you, the veteran, have a current diagnosis, or that an in-service event happened, or that you have qualifying service, well, that can be very useful later. So those kinds of findings may narrow what still has to be proven. No, that's a good thing. But Ortega reminds us that you still have to read carefully. You cannot just scan for the phrase favorable findings and assume all of them help you. Some do, some do not, and some are mixed. Now, here's what this means. Let's say VA says, yes, you have a current disability. Well, that's usually favorable. Or VA says, yes, we concede toxic exposure. Well, that's usually favorable as well. Or VA says, yes, there was an in-service injury. Well, that's usually also favorable. But now imagine VA says, we favorably find your condition existed before service. Now, that may not be favorable at all. It may actually make your legal path harder by shifting the fight into aggravation or by weakening a presumption that could otherwise help you. That is why words are not enough. You have to ask, does this finding help me win this claim? If the answer is no, then Ortega gives you a strong argument that the finding should not bind later adjudicators. Now, the case also addressed something else that matters in AMA. Prejudice. That's a word that lawyers use a lot, but the idea is simple. Even if VA made a mistake, the court often still asks, did that mistake actually matter? In Ortega, the board sent a notice letter after 90 days, after the 90-day evidence window. So picture that. The board sends a letter after the 90-day evidence window had already expired. So if you selected that docket for evidence, and you get 90 days, veterans to provide that evidence. Or even after a hearing docket or hearing that you have held, you get 90 days to provide evidence. So imagine receiving a notice from the Board of Veterans Appeals again that says maybe you have another 90 days after that evidence window had already expired. Now it sounds bad, and honestly, it's not a good look. But the court did not decide the big notice question in a broad way because Ms. Ortega could not show harm from it on these facts. So why not? Well, because she had used the evidence submission lane, the form itself told her she had 90 days, and the court said there was no sign she actually tried to submit evidence and got blocked by the notice problem. So the court treated any notice error as harmless in this case. That is another practical lesson. A lot of veterans hear VA made a mistake and think that automatically means remand or reversal. Not necessarily. The court often wants to know whether the error actually affected the outcome or the veteran's ability to pursue the claim. That's where veterans get into trouble. They spot a bad notice letter, a mislabeled finding, or a sloppy explanation, and assume that the mistake alone wins the day. Sometimes it does matter. Sometimes it does not. But the mistake I see all the time is people focusing only on whether VA messed up and not focusing enough on how the mistake hurts their case. If you want to make a strong argument, especially on appeal, you usually want both parts. What did VA do wrong? And why did that error matter? Now, Ortega is a good reminder of that. Now, let's talk about what else happened in the case, because it adds important context. The court also found problems with the foot claims beyond the mislabeled favorable finding. It said VA got inadequate exams and that the board ignored evidence when it concluded the foot disabilities pre-existed service. That part matters too, because it shows the case was not just about word games. The legal labels were tied to real consequences. If VA starts from the wrong premise, uses the wrong standard, or relies on a bad exam, the whole claim can go sideways. That is why the court vacated and remanded several issues, including the foot claims. So this is not just a technical decision for lawyers, it is a practical decision about how veterans get boxed into bad frameworks. Now let's talk about the biggest real-world takeaway here. If VA says something is favorable, ask yourself one question. How does this help me get the benefits I'm seeking? Now, if you cannot answer that clearly, slow down. Read the finding again. Read the rest of the decision. Look at what elements of the claim are actually in dispute. Ask whether the finding helps with service connection, rating, effective date, nexus, aggravation, or some other required element. Because sometimes the finding helps, sometimes it does nothing, and sometimes, well, it quietly hurts. And this is especially important in cases involving pre-existing conditions. And that's because pre-existing condition cases are already tricky. If VA says a condition pre-existed service, then the legal fight may shift away from direct service connection and into questions about aggravation, presumption of soundness, and whether VA can meet its burden under the law. That is not always bad in every case, but sometimes a pre-existing finding can fit the veteran's theory if the real argument is aggravation. And the court acknowledged that point. But in Ms. Ortega's case, the court said the finding did not help her, so it was not binding. And that nuance matters. That does not mean every pre-existing condition finding is always unfavorable. It means you have to look at whether the finding actually helps in that specific claim. That is the Ortega rule in practice. Now let's talk directly to veterans. What should you do after this case? Well, number one, stop treating favorable findings like a magic stamp. It's not a gold star just because VA says it is. Number two, read the favorable findings section with the same scrutiny you bring to the denial section. Do not skim it. Do not assume it is all helpful. Ask what each finding does for your case. Number three, connect each finding to an element of the claim. Does it help prove current disability, in-service event, nexus, qualifying service, severity, effective date? If not, why is it there? And how is VA using it? Now, number four, if VA labels something favorable that actually hurts your case, that may be a point to challenge. So Ortega gives a practical basis for saying the label does not control. And number five, if you are arguing board or court error, think about prejudice. Do not just say VA made a mistake. Explain how the mistake affected the evidence, the legal standard, the available presumptions, or your ability to present the claim properly. This is how stronger appeals get built. Now, let's talk to VSOs, claims agents and attorneys for a minute. This is a case you want in your toolbox for AMA work. It helps when VA tries to freeze a bad premise into place by slapping the word favorable on it. It also helps remind everyone that favorable findings analysis should be benefit specific. The court basically said the right question is whether the finding helps the claimant get the particular benefit. Now, that is a very useful way to frame arguments. Now, on the prejudice side, Ortega is another warning that courts are still going to ask whether the notice problem or procedural error actually changed anything. So if you are preserving appeal arguments, build the harm analysis into the case early. Now let's talk about what this does not mean. This does not mean favorable findings are unimportant. They're still very important. This does not mean every confusing finding is harmless. Some are very harmful. This does not mean every mislabeled finding automatically gets you a remand. And it does not mean every veteran can ignore evidence windows and later fix the problem by pointing to a bad notice. What it means is simpler than that. VA's labels are not the law. The actual function of the findings matter. And if the finding does not help the veteran, it should not bind later adjudicators just because VA called it favorable. And this is a meaningful clarification. So the final takeaway from the Ortega v. Collins decision here decided by CAVC on April 13th, 2026 is a practical AMA case about two things. First, favorable findings are not only binding if they are actually favorable. Second, even when VA makes a procedural mistake, veterans still need to show how that mistake mattered. So here's what this means in real life. Read the words carefully. Do not assume the label tells the whole story. And do not let VA define a harmful finding as helpful just because it fits neatly into a box on a form. Because in veterans law, what sounds good on paper is not always good for the claim. And that is exactly why this case matters. I thank you again, everybody, for being here, joining me again for another video as we learn more about VA compensation, VA benefits, and interpret some of these cases, especially these newer ones that are coming out and changing the way we can look at claims and the way we can handle claims and the way VA needs to address various things as well. Don't forget, we appreciate your likes. We like you sharing the video as well, and we appreciate your comments and your subscribing to the video for more, or the channel for more, so that we can help and continue our work in, well, keeping everybody educated and informed, and for the purpose of making a smoother process between veterans and VA alike in the future. So thank you again, everyone. Enjoy the rest of your week.